Are you Mr. Cain? No. Yeah, I did make the wrong assumption. We're opposite day today. Okay, go ahead.
May it please the court, counsel. I'm Hugh Cain. Along with my partner, Brent Hinders, I'm one of the attorneys for Wapello County and the Wapello County Board of Supervisors. We're here today to visit with you about a settlement agreement and how to interpret it. The plaintiffs own a piece of property in a rural residential area in Wapello County. There are vehicles on that property. I suspect the neighbors would describe those vehicles as wrecked or junk. The county would describe them as a nuisance, and apparently the plaintiff would describe them as a valuable business asset. In early 2019, the county published a request for proposal, an RFP, request for proposal to clean the property. As soon as the plaintiffs learned that that happened, they filed a petition asking for both an injunction and a declaratory judgment. At that point, the attorneys for the parties became involved. As in all settlements, there were problems both of an uncertain defense and uncertain claims. So what would happen? The parties negotiated an agreement. And that agreement provided for a procedure, a sort of steps to solve the problem. The steps that were created would be a 90-day window to clean the property. The plaintiff would have the exclusive ability to clean the property for 45 days. Thereafter, the county would enter the property, tell the plaintiffs what more needed to be done. Then the plaintiffs would have to complete the cleaning.
Stop you right there. And it's my understanding that the county entered after 45 days and did that. And there's an affidavit saying that there was a letter sent, but the affidavit isn't in the record, or the letter, I'm sorry, the letter that was sent to the McNeals is not in the record, is that right? Do we have any idea, does the affidavit, or do we have any idea what the letter said, if it identified any specific vehicles, or if it said anything?
It shows in the affidavit by the county engineer, Skalberg, that he notified the plaintiffs as to what remaining debris, derelict vehicles, work needed to be done. That's what the record shows. So what happened, of course, is after 90 days, and after an additional 35 days, the plaintiff doesn't clean the property. At that point, the county enters the property because they have the right to clean it to the satisfaction of the county. They enter the property, they clean away the vehicles and the other debris, and then the second lawsuit happens. The second lawsuit is a non-jury claim for a breach of contract and again for an injunction. The trial court found on summary judgment that there were no genuine issues of material fact and decided that as a matter of law and interpretation of the contract that the county should win. On appeal, the Court of Appeals in a split decision decided that that was incorrect. And you folks granted What
I'm going to do is give you a chance for a mulligan on something you said in the Court of Appeals. Apparently, the Court of Appeals was troubled when you said that the county could, in its absolute discretion under the settlement, decide that a brand-new vehicle with current license plates was derelict and remove it. Is that the county's position?
I wasn't the person who made that statement. I think that's an easy answer because this court, under its rules on good faith and fair dealing, say that all contracts have an implied covenant of good faith and fair dealing. What that means is you can't imply an additional term and that the discretion has to be exercised pursuant to good faith and fair dealing.
In fair dealing to say that a brand new vehicle is derelict?
I suspect that that, of course, is a hypothetical that didn't occur here. But I suspect that the right decision would be if there was a brand new vehicle, it would be very difficult to claim that that was a derelict vehicle.
I mean, here's where I'm coming from. You have on the one hand, you have this contract language, I'm paraphrasing, but it says something like removal of derelict vehicles to the satisfaction of the county. And it strikes me that, at least in the briefing, the county wants to read derelict out of the agreement, and the McNeals want to read to the satisfaction of the county out of the agreement. So shouldn't we be looking for somewhere in between that gives effect to both language? In other words, the county gets to exercise some judgment, and it has to be to the reasonable satisfaction of the county, but the vehicle has to be in some way reasonably classified as derelict. Doesn't that seem to make sense?
Your Honor, as in all things and in all contracts, all of the provisions have to be given credence, because otherwise you read language out of the contract. I think the contracts provided that derelict vehicles were to be identified by the county engineer at day 45. That, according to the record, happened. The plaintiffs were notified what they needed to do. Nothing happens. When the 90 days run, plus an additional 35, then the county has the discretion to clean the property, quote, to the satisfaction of the county. And that included any vehicles that hadn't been removed that the county had identified.
As it says derelict, it still says derelict vehicles. It still says removal of derelict vehicles to satisfaction. I mean, there's sort of a principle in the restatement that when there's a satisfaction clause, the law favors an interpretation of reasonableness, not absolute untrammeled discretion that, if they had a brand new Lamborghini down there that you could have that removed, right?
Number one is paragraph 4 that deals with cleaning doesn't use the word derelict in the sentence regarding the property's clean. Rather, it says, other than the procedure provided, the McNeals waive and release any other statutory or common right to challenge the county's right to enter the property and to conduct cleanup activities.
Well, the procedure, then that leads you back into 2 and 3, which use that derelict vehicles phrase.
Steps that the parties agreed to. And in terms of go back to good faith and fair dealing.
When the parties entered into this settlement, what is your best argument that the McNeals understood that every car on their property was derelict?
First of all, when we talk about derelict, remember in a settlement agreement, which this county says, or excuse me, this court says, you are not to scrutinize inordinately the language of a settlement agreement. What the settlement agreement talks about is that all of the derelict is used, I think, 5 times in the contract. It tells the plaintiffs what they have to do to clean up the property. Now, in a settlement agreement, as this court has noted, there are always uncertainties, both in the claims and the defense. The record doesn't say why the word derelict was used, but it strikes me as reasonable that the plaintiffs aren't going to admit that what they have on their property is a nuisance, because that causes them problems. So if you can't use the word nuisance to describe those vehicles, then what's another word? Derelict means forsaken, abandoned. That's probably the best way to have described it.
Argument that using the adjective at all, they could have just said the vehicles, and every vehicle on that property would have been subject to cleanup. And so when I read it, it suggests to me that there were perhaps some vehicles that might have been derelict and perhaps some that weren't, because otherwise you wouldn't have needed that term at all. And so what I'm trying to get to is, did the parties have some sort of mutual understanding of what that word meant when they entered into the settlement, or did one party know what the other side meant by that word? So in other words, both parties understood that the derelict vehicles meant the ones that didn't have tires or were up on blocks or had cracked glass or what have you, the ones that weren't running, versus other vehicles that perhaps weren't subject to that cleanup.
Recall that the Court of Appeals looked to extrinsic evidence in particular looked to the affidavits that the plaintiffs filed. I think those affidavits are very telling. They don't deal with the mutual understanding of the parties. They deal with the parties' undisclosed unilateral understanding. What do those affidavits say? They say, we didn't think that there were any derelict vehicles on the property.
I think the affidavits are actually helpful to you because the affidavits don't say there were any particular cars that were in, nice condition that could have driven off the lot. Instead, they say, we didn't think any of them were derelict because they were being used as part of our business. And one can argue that wasn't the county's interpretation, and probably isn't the common meaning of derelict.
The vehicles then that would have been on the property, according to the plaintiffs, are operable vehicles. That was certainly never the intent of the settlement agreement when you look at it. The settlement agreement at least 5 times talks about derelict vehicles, talks about
Any vehicles actually removed? Does the record indicate one way or the other?
it indicates in an affidavit that 16 vehicles were removed. And I believe that's in the
By them, I'm sorry.
plaintiffs.
During the 90-day period.
Did the plaintiffs ever remove any vehicles from the property during the 90 days plus the 35 days? That would be in Skalberg's affidavit, who is the county engineer.
The mines?
So the meeting of the minds were the attorneys that negotiated a settlement of uncertain claims where they determined that the best way to resolve these uncertain claims was to create a window during which this would be cleaned up. And if to go back to the idea of good faith and fair dealing, this court has said, what's the essence of good faith and fair dealing? Essence of good faith and fair dealing is when neither party takes an action to either destroy or injure the fruits of the contract for the other party. So what's the fruit of the contract for the county that was the cleanup of the property? The Court of Appeals decision eviscerates that fruit.
It's also true that the McNeals get the benefit of that agreement also, right? I mean, it's not a one-sided deal. You would agree with that? Is it an all or nothing situation where either every vehicle is derelict and the county can come and sweep out all, or the county has to only take the derelict ones? In other words, if they, pull up in the new Cadillac, the county doesn't get to take that, but the county gets to take the ones that they might reasonably agree, or at least that the McNeals would understand the county would view as derelict.
From our standpoint, the meetings of mind were that all the vehicles that were on the property were derelict. Because otherwise, why would the contract 5 times have used that?
Going outside, I mean, both sides, it strike me, go outside the agreement. The agreement says derelict vehicles shall be removed to the satisfaction of the county. That's the operative language. You're saying all vehicles, they're saying none. It doesn't say either of those things.
Derelict. And the only evidence that perhaps is the best is if you take a look at appendix pages 48 and 49, they show you the condition of the property at the time that the RFP was submitted. And it shows, perhaps not at bird's eye view, but it shows a number of problematic vehicles. In fact, all of the vehicles are shown to be rather problematic that are in that picture. So,
And in the absence of the settlement agreement, what would have been the process and procedure?
the case would have proceeded to trial. There probably would have been a counterclaim for nuisance, and then there would have been litigation over were the vehicles on the property a nuisance, and the plaintiff would be trying to get the court on a declaratory judgment to declare that they had the right to have those vehicles present, and then there was a request for an injunction. That's what would have happened.
Bringing an abatement action And then there would have been a factual determination on whether the cars constituted a nuisance under the statute.
Would be the case. And that was the uncertainty that resulted in a settlement agreement that this court has said you should not scrutinize the terms inordinately and that you should look with favor upon it. And you should, and thank you, my time is up. Not only was the thought has now escaped me. So thank you so much.
With the bad anyway, so that's okay.
Thank you, Your Honor. May it please the court. I kind of want to start with what Justice Mansfield was saying before, that we are trying to write to the satisfaction of the county out of this contract. And I don't think that that's exactly correct. We have, and the McNeals have alleged, that they believe that every car was not derelict out of the 16 that were removed from the property. Now, I think this court has to accept that as true, given that we are at the summary judgment standard, and that's what those affidavits say. But
Go ahead, Chief.
And also the settlement agreement doesn't say, I expected to read in the settlement agreement something to the effect of, the McNeals acknowledged there's some derelict vehicles that need to be cleaned up. There's no acknowledgement there either, is there?
not.
There's to clean up, which includes removing derelict vehicles.
Exactly.
Discussion about they did not remove one vehicle. Did they clean up the property in any respect?
The affidavits that were submitted show that they did take any steps to do anything at that point.
The issue, you say some of the vehicles weren't derelict. It's your breach of contract case. I mean, so you have the burden of proof. Don't you have the burden to show that they breached the contract when, which allows them to remove derelict vehicles to their satisfaction by demonstrating that at least one vehicle that was removed was not derelict. What is your proof on that point?
We have the McNeal's affidavit, which they say that they didn't believe that they were derelict, and that they are in the automotive industry as mechanics or in auto sales. And if we look at the definition that I think Mr. Cain was going to start talking about, but starts the Court of Appeals opinion that derelict means forsaken, abandoned, cast away, the McNeal's affidavits don't establish that.
Counsel, we would define that word the way that the parties did. So if the parties define it as brand new Porsches, derelict means brand new Porsches, right? So what we care about is what the parties meant. And if your client is saying that they entered into this agreement using the word derelict, but none of the vehicles were derelict when they entered into it, that's going to be a pretty tough one to swallow, because why would the county have been worried about that?
Derelict, if it's not defined, then we give it its common and ordinary meaning. And that's what the Court of Appeals did, is they gave it the common and ordinary meaning.
You have the burden of proof. I'm looking at your evidence. I mean, I did look at the record. You have these affidavits where they said, we did not consider the vehicles derelict, meaning the vehicles as a whole derelict, basically because we use them in our business. But not a single photo provided by your clients of any vehicle, I mean, so that we could look at it. There is a photo of one vehicle provided by the county, and it looks pretty derelict. So, I mean, what are we supposed to do on that record?
Keep in mind, in that affidavit, they've stated that 9 of the vehicles were licensed and registered under a dealer license and were provided VIN numbers. And they explained what the purpose and the use of those for. And so they're not being forsaken or abandoned. They had an actual use for them. They were registered under their dealer licensure.
Nuisance. I mean, you're in the business of law. You can't pile 1 million Northwest reporters in your front yard, right? I mean, so I don't understand what you think the county got out of this settlement agreement. They had a statutory right to abate a nuisance. They could have done that. Whether or not the vehicles constituted a nuisance would have been litigated. And I take it your position is, no, actually what we did is we entered into a settlement agreement so we could litigate what derelict vehicles means.
Know if that's necessarily true, Justice McDonald. To take one step back further, the McNeals started the underlying litigation, and their litigation was, hey, county, you didn't provide us notice for this nuisance claim. And we think that you cannot abate this nuisance because you have not provided us timely notice. And what happened with this settlement agreement is the McNeals have stipulated that they have received timely notice for it. And that's when you look at when the clause that says that the McNeals have given up any statutory or common law rights to contest the ability to the county to go in, that is a benefit that the county has received by entering into this.
Not only of their right to enter the property, but also a waiver of any challenge to their right to conduct cleanup activities. Under the terms of the settlement agreement, they can go in, they can clean it up, and it's to their satisfaction. I mean, what am I missing?
That's outlined in the agreement, yes. They have given up that right. But the procedure in the agreement is they can only, they being the county, can only remove derelict vehicles. Now, and it's our position, if they remove one derelict vehicle, the McNeals are entitled to, non-derelict vehicle, they're entitled to compensation for that.
Performance, what obligations do the McNeals have when the county comes in at the 45-day mark and says, all of these vehicles are derelict, you need to clean them up, and then they just don't respond? I mean, at that point, haven't they waived or forfeited any right under the agreement?
So because they would have been in the exact same position that they're in now, because the county would have come in and waived the settlement agreement and said, hey, we get to decide all of this. You can say that these cars aren't derelict until you're blue in the face, but you've given up that ability based on the settlement agreement. And that's not what the settlement agreement says or does.
Agree. I mean, we don't necessarily have to accept their position, but we don't have to accept yours. I mean, we're the court. We can decide you're partly right and they're partly right. But my concern is, again, it's summary judgment. You're suing for breach of contract. Your position, you know, they're allowed to remove derelict vehicles to their satisfaction. Don't you need to have some proof that at least one vehicle, you know, for one, if you want to say there's one vehicle they breached as to that one's was not derelict?
Under the common understanding of derelict, because it's not defined in the contract, that we have established that. Certainly as it relates to those 9 vehicles that were provided VIN numbers and are all registered.
I mean, they didn't have plates on them that were when the county went on the property. So the county has no way of knowing when it's going on the property, when it has the tow service go on the property, whether they are registered, whether anything, because they have not, I suppose there's a VIN number. They could go back and contact DOT and say, is there a current registration for that VIN number, if they can get access to that information. But it's not readily available. It's not apparent when you're looking at the vehicle, is it?
Assuming these facts in the light most favorable and the reasonable inferences that come from them that we're required to at this stage, that you can get to that place. And it very well may be that we try this case in a year from now and that district court judge says, you know what, 15 out of these 16 cars are derelict and were rightly removed.
What effect do you give to the phrase "to the county's satisfaction"? What does that mean?
Means, I think, and actually, I was kind of chuckling, Justice Mansfield, you kind of stole a bunch of my argument with which we were discussing with Mr. Cain. It actually, you can't write out derelict, and derelict has to have a meaning into that, and the debris. So they're only allowed to remove, to their satisfaction, derelict vehicles, debris, or repair the structures.
Why did they get some leeway in defining what's a derelict vehicle? I mean, derelict vehicles to their satisfaction. If I tell my son, I want you to remove, you know, dirty clothes from your room to my satisfaction, I get some leeway in defining what are dirty clothes, don't I?
It's easily left some of the derelict vehicles there, and if it was to their satisfaction, they could have been okay with that.
That was sent to your client halfway through when they came on and said, you haven't done anything, we expect you to remove all of this stuff. And it seems like that you have not, in your summary judgment filings, you did not dispute that letter was sent, even though it's apparently not in the record. So they send you the letter, you don't dispute the letter at the time, and then if we go back to the settlement agreement where your client, other than the procedure set forth in the settlement agreement, they waive their other rights, isn't that part of the This. The county has identified what they consider to be derelict and needs to be removed. You don't respond and say, oh, no, those aren't derelict, or do anything, and then at the end, they go ahead and remove. That seems to be the procedure.
I think what happened at that stage then is that they received that, and the county, based on the county's interpretation, they think they get to do whatever they want with it. And the McNeals could have said no, and they still would have come and taken those vehicles.
They'll say,
I think I agree with Justice Oxley. It was baked into the agreement. Halfway through it, they were required to show their hand. We say these vehicles, this is what we're talking about. And then by non-action or ignoring it or whatever it may be, can't that be implied, just like the contract was written up? Okay, the lines have been drawn in the sand. We can now take the next step.
Could be implied, but I don't think that would be a proper interpretation of it, because I really think that it doesn't necessarily matter at the end of the day, is because we would be in the exact same place. If the McNeals had run and filed a lawsuit the day after, we'd be dealing with these exact same arguments all the way through. And it doesn't matter that they did it at the time that they received that letter in 45 days, or the day after or shortly after the vehicles were moved in August later.
the specific language. Under paragraph 2, 45 days after, the McNeals grant the county the right to enter onto the property and to determine what remaining debris derelict vehicles. And so isn't that what they did? They entered and they determined 45 days in. Your client gave them the right to do that, to determine what derelict vehicles are, and then gave up the right to complain about anything other than the procedure.
That the county was allowed to come in there and make that determination, and they did do that. But they're
Go together, isn't that kind of hand in hand to the satisfaction of the county?
I don't believe it does, because they're still constricted. The county is still constricted under the terms of the agreement that they're only allowed to remove debris and derelict vehicles.
To determine what is derelict.
But then what happens after that is, and based on the next paragraph of paragraph 3, is that they're allowed to remove those items from there, and that's what their position is. But they're still constricted under those terms that it's derelict.
Methodology that the county should have used, or that your client understood the county would have used to determine a vehicle that is derelict from one that is not?
I think that the agreement should have outlined and not made that breakdown.
So what were they supposed to do? What was the methodology that the county was supposed to use according to your client?
Under the same terms of the agreement, so they had to kind of roll the dice and make an educated decision as to whether or not those items were actually derelict or not. And like I said, they might be right on some of them, but they might not be as well, and we only have to prove that there's one.
In the record, then, that they didn't actually cause any vehicles to be removed during the 90-day period? Yes.
That there's the affidavit from the county individual that says that there were no vehicles, or it was in the same condition as it was when he originally came out in 45 days.
Agreement ambiguous?
I don't believe that it is, in the sense that it's just a question of what is derelict. I mean, there's certainly ambiguity to that, and that's what the fight is over.
Oxley's point, what does it mean then to grant the county the right to determine what is derelict? It seems like whatever the county says is derelict, they identify it, they send a notice to the McNeals, and then the McNeals can move the property or not move the property, but I'm not sure what that means. If they don't have the right to determine what's derelict, it seems like you're saying they don't have that right, and it's actually up to your clients to determine which vehicles are derelict.
I don't know if it's necessarily up to our clients either. It's up to the fact finder to decide whether or not they're derelict.
It says it's the county's right, not the fact finder's right.
Good faith and fair dealing, and a presumption that the county was acting reasonably.
That they have not, I mean, that your client, in ignoring that second half was when you guys were up to bat. That first half, I think, was owned by the county, and it sounds like they did their work because they notified you, and your client didn't seem to dispute it, whether the letter's attached or not. But They completely tanked on that. They didn't do anything. If they had made some comments, I disagree. Vehicles 3, 12, 9, whatever, those are not derelict for these reasons. I think that's why we'd be here today. But for your client to have done absolutely nothing by way of saying why something is or is not derelict, or doing any other cleaning, like even taking some Windex to a supposed derelict car and cleaning the window, nothing. It just seems like your clients, in a sense, waived their opportunity to really have a fight about this.
I don't believe that they have, because they would have, I think that they send the letter and say, we don't believe this is derelict, and then the county says, no, we,
Just remove the vehicles and put them somewhere where they were supposed to have been and not on their residential lot.
had the ability to do that. They could have do that.
Of the settlement agreement,
I don't believe if
move them?
we're derelict, yes. But as I stated, the McNeals didn't believe that they were. Thank you.
Thank you. Just a couple of quick points, which is one of the ways that you interpret a contract is through the actions of the parties. That's pointed out by Judge Greer in her dissent. And I think one of the points that is very prescient there is that the plaintiffs were told 45 days into the process what they needed to do. Nothing happened. They clearly understood what needed to be done. And from a practical standpoint, that's a way to construe the contract, is that the plaintiffs knew what they needed to remove and they chose not to. The other issue I guess I just mentioned in passing is discretion. While the court doesn't like to give unfettered discretion to someone, the Iowa Fuels case says specifically that if it's clearly designated in a contract, one party can give up its discretion. And that's what I think happened here. And the attorneys for the plaintiff gave up that discretion when they agreed to the language that said the property will be cleaned to the satisfaction of the county. And I think that that's critical here, is that when you interpret the contract as a whole, that the plaintiff knew what they needed to do to clean the property. They chose not to, and the benefit of the bargain that the county got, the fruit of the contract, was to have a clean lot. And that's what we obtained at the end of the deal. The Court of Appeals would eviscerate that by requiring us to start over. That is all I've got. Thank you so much.
The case of McNeal versus Wapello County is hereby submitted, and the court is adjourned for the day. Thank you.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.